expect by numbers 47 and 48 as
adjournment. And over. Yes, next. Yes, next.
Motion item 1.
Yes, Mr. Mohammed.
Since I am an assistant teacher at MD School Society in the district of Kachara. On 18/4/23, I was on leave. But 19/4/23, when I wanted to come to school, suddenly this person was working. So I had to seek some medical.
What is your prayer, Mr. Mohammed? Impugn order dated 26/4/2023. Which page?
That page 24.
Page 24. This one. Only 1 day salary.
Only 1 day salary.
We'll issue notice. 1 day salary, it's okay. We'll decide it later.
No, earlier 24/7.
Mr. Mahmood, had it been a maybe let them file affidavit, will decide it. Is it a, if it is a continuous wrong, we'd have heard you for interim prayer. It's okay. I heard you send you notice 6 weeks, extra copies 3 days. 6 weeks of visa data. And in the meantime, you file your affidavit.
I think so.
You may not, there was a direction to file affidavit, but I have filed it just now.
You have filed it.
This morning.
It stated that the affidavit as required has been filed, which is not on record. List along with the affidavit next week. Interim continue. Interim continue. Sorry, no interim. Then on the next day we'll get medical college. What interim you want? Non-creamy layer. Directing the respondent, particular respondent as what? Declaring the act of the respondent. Which act of the respondent to be declared? Directing the commanding the to issue non-creamy to the cashier who belongs to. Where is the refusal to page number? No, where is the refusal? Pending. What you will say? No, you pass an order, dispose it off. Mr. Pegu, somebody makes an application for non-creamy layer OBC certificate. You may either give it on the facts or you may not give it on the facts, but you pass an order so that the person knows whether he is getting or not. Because this is medical admission, very, very time bound. We just pass a order, you pass a written order within 2 days. And if the person is still aggrieved, we come to the court again. Okay. Heard MS SB Chaudhary and concept of teacher, also heard Mr. G. Pegul and your additional senior advocate. Your additional senior advocate for the respondents as well as Mr. G. Gugoi for the for the respondents number 1 and 2, that is CCC for 1 and 2. The petitioner, Reena Das is the mother or the candidate? Reena Simarin Rani Das is the mother. The petitioner Sima Rani Das, no, the daughter of who had made that application? Which page? Page number?
Page 21.
The daughter of the petitioner, namely Sayona Kashyap, had made an application for a certificate to be granted for an application for certificate of non-creamy layer in the OBC category for the purpose of utilizing the seat certificate in the ensuing medical admissions that are going on in the state. It is informed that the medical admissions are presently in progress, and therefore there is a urgency on the part of the petitioner for the application for non-criminal layer to be considered and give past the reason order. As the application is kept pending and no order is passed, district petition is instituted. The respondents have filed an affidavit stating as to why the certificate is not being granted. Instead of deciding the matter as to whether the certificate is to be granted or not, we direct the who will issue. Deputy Commissioner of which district? Sonitpur, to pass a reasoned order on the application of the petitioner for a non-criminal layer certificate for the OBC category. The order that may be passed to contain a reason justifying either the grant or non-grant of the affidavit. As there is an urgency on the part of the petitioner, the order be passed within a period of 2 days from today, that is on or before. On or before 1/9/2023. Petition disposed of accordingly.
Item 3.
Pass it immediately so that if it is refused, they have another opportunity to come to the court. What kind of protection? No, what kind of protection? The health department is not a party. Next slide. Health department is not a party to whom we can issue the direction. For what? The mandamus to accord approval selection. Notice? No. What kind of interim order? No interim order. So we issue notice. You want a disclosure that the director pass an order. Yes, Mr. Gogol, what is it? No. He's saying it is pending at the level of director. He wants an order to the director, pass whatever order he wants. So we are not deciding the matter. Fair enough. Heard Mr. N. House, counsel for the petitioner, also heard Mr. K. Gugui, learned counsel for the respondents in the higher education department. Miss, whom do you appear? You are together. Anybody else? The grievance of the petitioner is that she had participated in a selection process for the post of principal of Mankachar College. As per the advertisement dated 18/2/2022, the selection process had been carried forward by the authorities of the college as required under the rules, and the result of the selection had been transmitted to the Director of Higher Education, Assam, for his approval and further requirements as for his approval and for doing the needful as required under the law. The limited grievance raised is that although the matter records had been transmitted to the director, but the director has not taken any decision as yet on the approval that is required to be granted. Sorry. In view of the limited grievance raised, instead of issuing notice, we require the director to consider the records of the selection committee as may be transmitted, and upon considering the same, a reason order be passed under the law as may be advised. The requirement be done within a period of 15 days from the date of receipt of the certificate copy of the order. 4 days. Okay, with a period of 4 weeks from the date of receipt of the certificate copy of the order. Dispose of recording.
Item 4.
Oh, yes. Setting aside the order dated 14 February
given a chance. I have not read it.
Where is the order of
Please, sir.
these? Where? Your stand is that this show cause notice was not received. The respondents in the SEBA to produce the records as regards service of the notice to the petitioner institute as reflected in the second paragraph of the impugn order dated 14/2/2023. If you have served, we'll take it in a reply. If you have not served, he needs a hearing.
Good policy.
List.
Item 5.
Yes, item 5. Constitute an independent inquiry committee and let it verify the original mark sheets. Why? No. Why at the instance of a third party, the original mark sheets of the selected candidate should be again verified? Sorry. 45. What is it? There is no page 45. Oh, indeed, there is. Sorry. Page 45. 45, yes. Serial number 25, yes. Serial 40, page 45. Page 45, there is only serial number 1 to 9. Which page you are referring? No, 45, there is only serial number 1 to 9. Starts with Sonali Chakraborty, ends with Samim Akhtar Mohinder. Maybe your paginations are wrong. The petitioner to verify the paginations and submit. Just again.
Item 6.
Please check up. Possibly your copy and this copy is not matching. And correct. Next. Yes, Mr. One minute. Just a minute. Matter pertains to promotion. Directing the respondent to consider the case of promotion. And what interim you are seeking? No interim. We should notice. Mr. Munir, do you expect the order today itself? Mr. Munir, a promotion matter, the court cannot decide on the first day on the motion itself. So let us issue notice, we'll hear them. If you are entitled, we'll issue the direction. We understand. That is your submission, but don't you think before issuing a direction, we'll have to hear them? See, we are a little short of time. Notice, when do you want? But Mr. P.K. Munir, like answer for the petitioner, issue notice returnable on so respondents to file their affidavit in the meantime. Mr. Munir submits that in respect of the criminal case that was lodged against the petitioner in Mukalmua PS case number 252/2023. The final report had been submitted in favor of the petitioner and therefore he is now entitled to be considered for promotion. Respondents to state in the affidavit as to why an appropriate direction should not be issued to consider the case of petitioner. The copy of the final report produced is kept on record. Last one, yes, next time.
Item 7.
Yes, Mr. Manna. Setting aside the impugn order to register.
They applied for pharmacies.
Notice.
But not.
But Mr. Y.S. Manna, returnable how much? Sorry, 2 weeks. Returnable 2 weeks, but the extra cost. List on switch. Sorry. 1, 2, and 4, 3 CCC. Mr. Pegu, you are a CCC, I think. Are you a CCC? Pegu CCC.
Item 8.
Yes, item 8, Mr. Raman. In the interim, may please to pass an order ensure that SMC of is continuing. That's it. They're trying to terminate before 3 years.
Yes.
Which is the impugned order?
Well, it's page 6 in the
Sorry,
page 6 in the
page 6,
6.
16 is the approval order. So they have not given approval. It will value at order DC to 31.8. We stayed at 31.8. Valid up to 31.8 approval order. We passed a limited stay regarding that validity up to 31.8. Yesterday, one order was passed. Just check up on the similar circumstance. Same order.
Item 9.
Understand. A representation for what purpose? Set aside the order of respondent number 4 to be the in charge. So whoever is eligible will be appointed. So you have made an application that I am the only eligible. So yes, Mr. Chisti, what is it? Both the parties. So notice or disposal? To hear him and also the other person and pass a reasoned order. Heard Mr. H. Talundal and counsel for the petition, also heard Mr. S.M.T. Chisti and counsel for the respondents in the education department, secondary education department. Considering the nature of the order proposed to be passed, notice not required to be issued to respondent number 4, Jogen Burma. The petitioner, Aisha Khatun, is aspiring to be the in charge principal or headmaster of what school? Of Borpeta High School will be headmaster, not principal. In charge headmaster of Borvita Dolorpothar High School in the Borpeta district, which was previously functioning in the name of Borvita Dolorpothar High Madrasa. There was the respondent number 4. Why did you make this respondent? Why is he a necessary party? But he's already been set aside by the court, you say. So then he's no longer necessary. Mr. Chisti, what do you say? Because there is already a court order.
Only they take over.
So then why should he be heard again?
Whether that court order was followed or not, that's something that has to be asked.
Where is the court order? Which page?
Also, there is a change versus 37.
Page 27.
In the relevant court area, page
Mhm.
29. If a remand
It
is
is-
the secretary.
The matter is remanded back to the secretary to take final decision with regard to the selection of. So final decision.
Yes, earlier was just decided.
Therefore, neither the petitioner nor the respondent number 4 fulfills the criteria. Who is the petitioner?
One Laboram Polina.
And who is the respondent number 4? That same person, Jogen Borman.
The petitioner is aspiring to be the in-charge
Of course.
headmaster of Borpeta Budolak High School under in the Borpeta district, which is previously functioning in the name of Borpeta High Madrasa.
Earlier, by an order dated 24/2021 of the Director of Secondary Education Assam, Jogen Borman was temporarily allowed to hold the charge of Superintendent of Borpeta Dolorpathar High Madrasa, in addition to his normal duties as assistant teacher. The said appointment was assailed by another teacher, namely Laboram Polita, in WBC 283/2021, wherein the judgment dated 3/8/2022 had been rendered. The relevant paragraph of which is extracted as below. A reading of the aforementioned extracted judgment of the court makes it discernible that there is a judicial pronouncement against the eligibility of Jogen Borman to be the in-charge headmaster. And over and above, by the same order, even the writ petitioner therein, Laboram Polita, had also been declared to be ineligible. By the said judgment, the court also issued a direction to the Secretary to the Government of Assam in the Secondary Education Department to take a final decision with regard to the selection of the teachers for holding the post of Superintendent of Borpeta Dolorpathar High Madrasa, which now has to be read to be the headmaster of Borpeta Dolorpathar High School. As the regular selection process is yet to be initiated, the writ petitioner, who claims himself to be eligible to be the in-charge headmaster, had made a representation dated 20, which page? 32, and made a representation dated. Where is the date? 20. No, dated 28/2/2023. Submitted a representation dated 28/2/2023 before the Commission Secretary to the Government of Assam in the Secondary Education Department, as well as to the Director of Secondary Education Assam, that in the interregnum his case may be considered for the purpose of being the in-charge headmaster. As no response had been made by the respondents to such a representation, this writ petition is instituted. In the circumstance, we direct the home director, or directing the Director of Secondary Education Assam to give a consideration to the representation of the 28/2/2023 of the writ petitioner claiming to be the in-charge headmaster of the school. By requiring the representation considered, we clarify that it is not a direction or suggestion in any manner to appoint the petitioner, but it is a requirement of the director to consider the matter on its own merit and pass a reasoned order thereon. In doing so, if the director is of the view that any other person is also required to be given a hearing, the director shall issue notice to such person. The requirement of passing a reasoned order be done within a period of 4 weeks from the date of receipt of the certificate copy of the order.
Item 10.
I think the Bormon is not required because court had already declared to be. Why don't you delete Bormon? Instead of issuing notice, they issue. Consider the nature of not issuing direction. However, from the facts and circumstances, as indicated herein above, we are the view that the respondent vote is not a necessary in the party and can stand deleted. Facts lagi. Yes, Mr. Monta. So you want to be called for the interview?
I was not called for the interview.
No, you want to be called for the interview.
I played that as a very limited player. As the mother may have already committed.
No, did you participate in this election?
So, madam, we said that we were not considered an my document which is put in as
Reconstituting the selection committee. Can it be done? Then we have to stay that selection process. Because if in the meantime the other person is appointed and this person having a better credential was not called, not calling itself is an illegality. His right is violated. No, whatever it is, we say that no further steps pursuant to that advertisement. Mr. Mohanto, you are thinking from the petitioner's point of view. We are thinking from every point of view. Will it not be an illegality now if I order a reconstitution on the very first day itself? We have to hear some others. They may say that no, we should not, this man refused to come. If that is the stand, then what will you say? So definitely we'll have to hear them. Very well. We are protecting you, Mr. Mohanto. Mr. P. Mohanto and counter petitioner also. Mr. A. Tobilan and counsel for the respondents in the higher education department issued notice returnable on at a fixed date. Extra copies to the Standing Council with the 3 days steps on respondent number 3 and 4 by registered post as well as by Dusty, and thereafter filed affidavit before the court. Dusty through the registry. The petitioner is aggrieved to the extent that in the selection process pursuant to the which advertisement? Which advertisement? No, date. Pursuant to the advertisement dated 13/6/2023, the petitioner, did you submit your application? The petitioner offered his candidature. Advertisement for the post of assistant professor in Arabic in the DP College at Jonia. The petitioner offered his candidature. Pursuant to the advertisement, a selection board stroke committee was constituted on 5/8/2023 for filling up the said post. The grievance of the petitioner is that in spite of having offered his candidature, the selection committee did not issue any call letter to the petitioner for participating in the selection process. It is stated that in the meantime, the selection committee had processed the matter and it is not known at what stage the selection process is at present, whether it has been forwarded to the director for approval or it is still at the level of the school authorities. However, considering the prima facie case made out, in the interim, it is provided that no further progress shall be made pursuant to the advertisement dated so-and-so for the post of Assistant Teacher Arabic in the BP College at Jonia. No, one word distance the whole thing, Mr. Mohammed. Why?
Sorry.
We have stated Jonia firstly, and secondly, even if I have not stated, the correction can also be made at the end of the order. Not forget it, keep your seat. Please don't do it. It's a waste of time. Keep your seat.
The material did not further progress in it. The selection process for the post of excellence worker in Arabic in the DP Sonia College of Jonia.
Jonia. So the Arabic.
Statement which material did not further progress in it. In the selection
No,
process.
no, or the Arabic.
Further considering the prima facie case made out in the interim. But,
Further concerning.
however, considering the prima facie case made out in the interim, it is material did not further progress be made in the selection process for the post of assistant professor in Arabic in the BP Sonia College of Jonia.
Jonia. It will be yes. The respondents number 3 and 4, upon receiving notice to produce the records of the selection committee to examine as to whether any call letter or notice was issued to the petitioner for appearing in the selection process. List on Swetson. We'll verify whether it was issued or not. If not issued, we'll set aside and send it out. Hmm. That one is gone, you correct it. This one, which page? This one is page 45. In independent inquiry, that is verified at page 45. Such a same matter, in that case, page number is different. 25, 7, 89%. Page 49. 326 out of 500 will be 320. So double is will be 64. 64, 65.2. What do you say? No, we understand. If you come to page 45, Sabana Yasmin has been given 89% in HSLC, whereas her mark sheet at page 49 shows it is 64%. This is what he is trying to point out. What do you say? No, authority cannot make a calculation beyond what SEBA had given marks. But that will not render an illegality to sustain. The selection is already. This is of what? Which date? The select list. 23/5. Why have you come so late? No, Mr. Chaudhary. As you have come late, okay, and some people had in the meantime been appointed. Understand? In general, we cannot set aside the whole selection. You make the specific persons respondent, we'll issue notice. And if you are right, we'll set aside their appointment. We understand. But someone is also coming after 4 months after everything is over. So we'll issue notice at the best. Nothing beyond that. Notice you'll get it, but we can't interfere anything beyond that. Notice. 6 weeks notice. Notice for 6 weeks. You are issuing this one for the education department. Any other respondent? We have made some private respondents also. Notice raised up as private respondents.
Well,
Declaring the act of respondent.
Order is at page 28, page -28. Here it is written as Purushottam Boro. His name is Punna.
The page 28. What is page 28? Order. So this is an appointment order,
Appointment order.
but it is but you are actually Puno.
So because of this,
He is not been. Yes, what do you say? Understand? He says the spelling should be Puno, not Puran. Look into the documents and correct it if necessary. And what is the High Court case? No. What is the name? High Court made it alias. Where is that order? It's 25. Heard MSHB Jodri and counsel for the petitioner also had sorry, Pegu, your name, Mr. Also Mr. Panes Pegu for the education department. So Saikya, you appear for anyone? Mr. P. Saikya for the Deputy Commissioner Kanpur Metro. Considering the nature of the order proposed to be passed, notice not required to be issued to the respondent for 6 and 7. Respondent number 6, 7, 9. The petitioner as Puran Chandra Boro, alias Punor Chandra Boro, had instituted WBC 5267/2018, which was given a final consideration by the order dated 19/7/2019, with a direction that to the respondent authorities therein to verify the claim of the petitioner that he was selected for appointment as an assistant teacher as a grade 4, and if the said claim is found, and if it is found that the name of Puran Chandra Boro alias Punar Chandra Boro had been recommended, necessary appointment orders be passed. Pursuant thereto, the order dated 16/3/2023 had been issued by the Director of Elementary Education Assam, by which Puran Chandra Boro had been appointed as a grade 4 in the Bathopuri Boro ME school. The petitioner claims that the correct name of the petitioner is Punor Chandra Boro, P-U-N-A-R, and not Puran Chandra Boro, which was fact was also brought to the notice of the court in the earlier proceeding, inasmuch as his name was written as Puran Chandra Boro alias Punor Chandra Boro. This writ petition is instituted on the grievance that as the spelling of the petitioner had been incorrectly reflected in the appointment order, no appointment had been given to him.
Appointment has been given, but salary.
Grievance that although appointment had been given, no salary had been paid to the petitioner. In the circumstance, we direct the Director of Elementary Education Assam to verify the records as to who is appointed and also verify the testimonials of the petitioner regarding the correct spelling of his name. And if it is found that the petitioner is actually Punor Chandra Boro, and the appointment was also meted to Punor Chandra Boro, necessary orders be passed for salary, etc. of the petitioner. Requirement be done within 4 weeks. 4 weeks from the date of receipt of the certificate of the order. Got it.
Item 30.
Yes. Sorry. Notice interim order will be difficult. If anybody else is provincialized, they will be subject to the result of the petition. Then why do you need an interim order? Dispose everything. Do you agree? If Mr. Chisti agrees with disposal. Third, Mr. P. Professor and counsel petitioner also heard Mr. S.M.T. Chisti, then counsel for the respondents in the secondary education department. Issue notice written so and so. The petitioner claims that in the process initiated for provincializing the teachers of it's one school of Borthal Posari Girls High School, Morigaon. The name of the petitioners, although entitled for provincialization, had been left out. It is stated that in the posts that which are available for provincialization in the state school, none have been provincialized as yet. The respondents to file affidavit as to why the case of the petitioner was left out. Based upon the affidavit that we filed, final consideration will be considered on the next returnable date based on suits.
Item 14.
Yes, Mr. There's an interim order not to terminate. Should we grant the interim order or you oppose the interim order? No. What about the interim order? Rest will take care of later on. Interim order, should we pass the interim order or should not? Continuing from 2002, I think. A long time they were. I heard Mr. B.D. Das and Senior Counsel for the petition also heard the name J. Gogoi for. Who are they? Sorry. For the authorities in the NC Autonomous Council and Mr. S.M.T. Chisti, then Counsel for the School Education Department, Government of Assam. Issue notice, returnable 6 weeks. Respondents may file their affidavit in the meantime. It is stated that the petitioner had been working as a lecturer in MIL in the Sengya Sambodhan Senior Secondary School in Dima Hasao for the year 2002. Their claim for being regularly appointed had been processed and the matter is presently pending with the government. In the circumstance, the petitioner prays for an interim order that their services as it stands today should not be terminated in the meantime. Accordingly, interim order pray allowed petitioner services of petitioner not to be terminated until further orders. Pendency of the writ petition shall not be a bar for the respondent authorities to carry forward the process of regular appointment as already initiated. This Mr. Same order. Item number. Item 13. Same as item 13. Shall we pass it? Pendency of writ shall not be bar for the respondents to consider the case claim of the petitioner if otherwise entitled under the law.
Item 16, 17,
2017. 2015 matter. What is this? Which stated that when Senior Counsel, Mr. H.R. Chaudhary is having some inconvenience today, adjourned to be listed also. Which case? When will Mr. Chaudhary be available? Next week, date of the
12th September. Item 18.
No further adjournment. Item, yes, next item, Mr. Day. Time scale. Compassionate appointment 2012. After that. These petitioners are appointed in what capacity? Teacher or staff? Non-teaching staff. So after 2012, the ratio of non-teaching staff and teaching staff was changed. And because of the change in ratio, you are out. But go. Then what they are paid? Where is the order of appointment? No. Where is the order of appointment? Page number. Approval of the VC, the following appointments under contract. Who appears for the Body University? Who appears for Body University? Sorry. See, if we go to page 19, you have the file with you. No? Then how do you understand the case? If you don't get it, go to that. But even otherwise, they were appointed under compassionate ground. Okay. Can compassionate ground be an appointment at a fixed pay or a casual appointment? Compassionate ground is either you give or you don't give. If you give the whole thing, whole entitlement, or if you don't give, reject it. It is stated that, sorry, no, who is busy? Mr. P.J. Phupal, Body University is having some inconvenience, adjourned on the Inconvenient Council based on so and so, no further adjournment.
11 September.
Next day, don't take adjournment.
Item 19.
Yes. Non-payment of area salary.
Initially, I was appointed a function for OBB teacher. After completion of my PLS, I am entitled to get my
After completion of DLA, you are entitled to the full pay.
I am getting the present value, but the figure from 16/11/2019 to 28/2021.
So from 21, you are getting the full scale. But from 11 to 21, you are claiming for that period. Why? No, you say that you got the qualification of DLA. In which year you got the qualification? 16. So you are entitled after 19. Prior to that, you did not have the qualification.
From 16/11/19 to 28/2021, there is an order from the pilot.
No, that period we can consider, but not before that.
Not good. Apart from this pilot, there are other pilots for which I have contacted. I say a pilot. I have contacted from pilot 17/2004 to 27/2010.
Why?
Pilot was not paid. And OBD teacher, 1800 pounds.
Who appears? It's a big view. What do you say? No, what is your stand? They are entitled or they are not entitled? You're not ready. Adjourn on the pair of Mr. Ganesh Pegul and on the Education Department. We listed on.
20 and 21.
Mr. SP Sharma. It is stated that the conducting counsel for the respondent, Mr. SP Sharma, is suffering from conjunctivitis. Adjourn for.
Item 22.
Yes, item 22. D.K. Roy. None appears for the petitioner when the matter is called to investigate.
23.
Mr. B. Chaudhary, land counsel for the respondents in the assessing. In the BTC states that the affidavit is ready and will be filed within a week. Rare law, just after it.
24.
It's stated that Mr. A. Bhuyan, land counsel for the petitioner, is having some inconvenience. Adjourn.
26.
Who appears for the petitioner? No, petitioner who appears? Mr. Mukhtar, yes.
Second round of mitigation matter. First round was closed by your lordship's order matter. Page 71 matter.
What is the second round for? Borkhetri
You will
government.
not see pass an order directing the director of hand to pass an speaking order matter. The speaking order here directed by claim matter. It's by your lordship direction to consider my annexure J matter. He has not considered annexure J at all matter.
Where is the order of the court?
Yes, page 71.
71. For whom do you appear, Mr. Pandit? For whom do you appear?
He appears. Intermediate university has filed an affidavit matter.
The petition. University has.
University has filed an affidavit that they have connected it. It was saying the director matter in the month of February 2021 matter. But speaking order was much later than that matter. You are
No,
considering
let
that-
us go one by one. Where is the provision that some annexure J should be considered?
Yes, madam.
Where is that line?
Now, page 59 is the annexure J matter now.
No. Where is it provided in that order? You said the High Court order said to consider annexure.
Yes,
J.
yes.
Which line?
Yes,
No, where is it? We don't doubt you, Mr. Mukhtar, but we want to see it so that we can put it in our order.
yes, yes. Yes, sir. Paragraph 7 to page 74.
74.
Page 74, paragraph
Rejected
7.
on the ground of best number of students appearing. The seat view is appears in direct country statement of the deputy according to magistrate. Taking note of annexure J, page 57, document dated as regards number of students. Okay, now where is the impugn order?
Yes, next. Page 76, man.
76. Right, the order of the High Court. Where is the consideration of the document dated 19/2/2021? No. Court says you consider this case, but in doing so, also take note of the document dated 19/2/2021. Did the director take note of that document when the order was passed? It is not reflected in the order. No. Otherwise, you may have passed a justified order. But the court has passed an order. In doing so, you also take note of this document. So you are bound to take note of that document. Yes. We place it once again. Once again. Then what will happen to this page 76 order?
It is not people admitted that it's what selecting for because initially it was said
So on your own volition, you withdraw this order. No, because this is a rejection.
yes, sir. Yeah, rejection.
So what will happen to this rejection order?
After seeing the placement of the university, it will not survive.
No, in our order, what will you provide? We say set aside.
And direct as per this.
In this one, reconsider it and heard Mr. S.K. Mukhtar, Land Counsel for the petitioner, also heard Mr. E. Tawila, Land Counsel for the respondents in the Higher Education Department. We also heard Mr. A. Ahmed for the authorities in the Guwahati University. Considering the nature of the order proposed to be passed, the authorities in the Borkhetri College are not required to be heard. The petitioner earlier instituted WPC 4446/2021, same petition, claiming for regularization, provincialization in the post of lecturer in philosophy in the Borkhetri College, as per the appointment letter dated 31/7/2010. In the said proceeding, an issue had arisen as to whether the number of students in the subject philosophy did satisfy the required number under the rules. Let me complete my order. Or you want to say something more? Please.
No.
So you finish your argument first, then I'll start. Otherwise, he is disturbed. When he hears two sounds, he can neither record my order nor what you were saying.
Yes,
Wait. If necessary, you will correct it at the end of the order. Yes.
The said proceeding and issue arising as to whether the number of students in the subject philosophy did satisfy the required number
Under the law. In the circumstance, there was a document dated 19/2/2023 providing for the number of students that were enrolled in the subject philosophy, and by the order dated 16/9/2021, the authorities were directed to reconsider the claim of the petitioner for provincialization by taking note of the said document dated 19/2/2021 which was Annexure J, page 57 to WPC 4446/2021. In the resultant process, the order dated 27/10/2021 of the Director of Higher Secondary Education Assam had been passed, by which the claim for provincialization of petitioner was rejected. This petition is instituted on the grievance tab, although there was a specific direction to consider the document dated 19/2/2021 while considering the case for provincialization, it was in fact not done so, and the provincializer refused without taking the same document into consideration. During the pendency of the writ petition, the respondents have produced a copy of a communication dated 23/6/2023, by which the director had informed that as per the mail dated 26/2020 of the Registrar Guwahati University, a total of 136, that is 15 major and 121 general number of students appeared in the final examination of the year 2016 against the subject philosophy in the Borkhetri College. And according to the respondents, the same number is sufficient enough for considering a favorable for provincialization of the service of the petitioner. In view of such stand of the respondents, the earlier order dated 27/10/2021 is set aside, and the matter is remanded back to the director for a fresh consideration by taking note of the contents of the communication dated 23/6/2023 of the director himself, made to the Learned Standing Council for the Higher Education. I think this is good enough. Anything you want? The director may do the needful as required under the law. Wherever you have to place, let the director do it. The communication also stated that as per a subsequent mail dated 27/2/2021 of the Registrar Guwahati University, the total number of students is 190, that is 16 major and 174 general, who had appeared in the examination of 2016. Why is it changing every time? Sorry. No, this man is unseen suffering for all this.
4 months.
4 months.
I don't know how long it will take.
We are thinking of making it lesser. You'll need 4 months. The request be done in the period of 3 months from the date of receipt. Copy of the order, the communication of 23/6/2020 of the director kept on record.
27.
So today, what can we do? Can we hear the matter? No, do you file affidavit? You want to file affidavit? Mr. U. Sharma, and counsel for the secondary praise for 4 weeks' time to file the affidavit of the prayer law list after 4 weeks.
28.
This 28. Here also no affidavit. You want to file? Mr. K. Gogoy, State Council, had a praise for 4 weeks' time to file affidavit prayer law list after 4 weeks.
29.
Again, no affidavit. Want to file? MSS Studio and counsel for secondary. Eliminate praise for 4 weeks' time to file affidavit list after 4 weeks.
Item 30.
Same order.
31. Item 31.
Let us adjourn it instead of passing on. Let us adjourn it for the day. You want to go to some other bench? He's saying AG appears, I can't take up. No. Today he says he's available, but I cannot take up. Last order is if the advocate general is unable to appear or to make alternative arrangement. Today he says he is available, but I cannot take up. What order you want? No. Should I pass an order not before me or I simply adjourn it? List this matter before any other court.
32,
Sorry, your name? H. Borua. Mr. H. Borua, then counsel for? No. For which department? For SSA, place for 4 weeks time to file affidavit, prayer or list of the 4 weeks. Short date. Date of understand? Yes, next item.
33,
33. No affidavit. Want to file? Mr. A. Pukan and counsel for which department? Elementary praise for 4 weeks time to file affidavit, prayer now list after 4 weeks.
item 34,
34. Yes. Praise for taking steps of service on the by trustee. Steps taken. Does the affidavit filed? Which page? 6. Okay, you are appearing. Mr. M. Khan and counsel for appears for respondent for 6. And praise for 2 weeks time to file affidavit, prayer note, list of 6 weeks. Service on respondent 6 is complete. After 6.
35,
No, you take a decision, whichever way you want to take. Now pending before the SLEC. State level, that committee, that one. Heard Mr. M. Khan, and counsel for the petitioner, also heard Mr. A. Pugan, and counsel for the respondents in the elementary education department. The writ petitioner, Chinta Kumar Ghosh, was subjected to, who is a teacher in the in which school? Teacher. No, where's the name of the school? Which paragraph I get the name? In the Isa Fields numbers 7 number line LP school in the Karimganj district was subjected to the process of provincialization, resulting in a recommendation by the district level committee. Which page? Resulting in the recommendation by the district level committee in its meeting of 29/12/2021, which is available as Annex 10, page 43 to the writ petition, which had been communicated by the communication of the Director Elementary Education, Karimganj, dated 1/1/2023. It is stated that the matter is presently pending before the state level scrutiny committee, and this writ petition is instituted on the grievance that the matter had not progressed further. In view of the above, the state level scrutiny committee is directed to consider the recommendation of the district level committee in respect of the petitioner in its meeting of 29/12/2021 and pass a reasonable order thereon. By requiring the State Level Committee to pass a reasonable order, we are clarifying that we are neither indicating in any manner that the recommendation is to be accepted or rejected, and it is for the State Level Committee to take their own decision as per law. Requirement be done within 3 months. 3 months from the date of receipt of the certified copy of the order.
36 and 37.
Mr. Sharma. What is this for? To pass the order dated 4/3/2022. And next page number 120. Figure showing its name. On the basic arranged to print media. So there is a dispute whether you have passed this junior basic course.
According to the director of education as well as SCLD,
But they say they don't have any record.
that does not mean that it was passed by the case 109.
No. What is the source of procuring these documents by the petitioner? From whom did you procure?
Basically,
No, Mr. Sharma. Any certificate issued by any authority, they maintain a record. There cannot be a certificate without record. They say we don't have record.
why
So, Mr. Sharma, so we ask you to file an affidavit. From whom did you receive the certificate? Who is the person who had handed you over the certificate? First tell us that. Principal. File an affidavit.
page 109 page 109.
What is there in 159?
Why records are not available? For 3 years.
But fail to give. Mr. Bora, who is in charge of this basic training? Not the principal, the higher authority. Who will be in charge? Let the director SCRT make an inquiry and submit a report. Because they are saying that there is a tussle between two persons to be the in charge principal. Somebody may have misplaced the record. If that is the case, this petitioner should not be penalized for that. Sorry, there is no record. That is your standard. Heard Mr. N. Sharma, learned counsel for the petitioner, also heard Mr. S. Bora for the SSA and Mr. A. Fugan for the Elementary Education Department. SCRT. By the order dated 4/3/2022 of the Director Elementary Education Assam, refusing what provincialization? Cancelling the provincialization of the writ petitioners is assumed in this writ petition. The impure order states that a question had arisen as to whether the junior basic training pass certificates of the petitioners are genuine and acceptable. The respondents were of the view that the records of the SCRT do not reveal reveal that the corresponding certificates relied upon by the petitioners were issued by the SCRT. The SCRT has also filed an affidavit affirming the same, that even after inquiry, they are of the view that no such records are available. If records are not available with the issuing authorities and the petitioners are relying upon a certificate to establish that they have passed a junior basic training course, we direct the petitioners to file an affidavit stating the source and the person from whom they have received such certificates that they are relying upon. Affidavit we filed within 1 week. This after this. You tell us the name, we'll make further inquiry from where he gave you the certificates. Whatever it is, you say it on the next day. We have already called item 30. We'll say it on the next day. You find your affidavit, whatever it is. Yes, Madam Chaudhary. Compassionate. Where is DLC? (25, 26). Where is the rejection? The usual date of retirement of the deceased servant is balance 3 years is not there. So the scheme says the balance 3 years is required. Acha, of OM requiring balance 3 years has been set aside. By whom? It is set aside. Okay, that is already set aside. So you go back and consider it without that aspect. What else to do? Where is the order setting aside the OM?
Item 49, page 63 to 65. There are 17, 18, and 19.
And this order has attained finality, Mr. Pegu. This order has attained finality.
Here at page 64, madam, it's accordingly struck down.
Page 64. Page 64. Which paragraph?
64, 65.
No, which
There
paragraph?
are 17, 18, and 19.
Where is the line struck down?
Page 64, madam.
Acha. This clause 1 of OM. Okay, it's okay. Say something more.
Page 65 and 66. In view of the paragraph 19, in view of the above, therefore this court answers the issue number 1 to the effect.
Yes, we've taken that part we have taken.
Non-constitutional.
Send it back. Third, MSSB Chaudhary, Land Counsel for the petitioner, also had Mr. G. Pegu, additional saying an advocate for whom? For the Deputy Commissioner Karimganj, as well as Mr. Ganesh Pegu, Land Counsel for the respondents in the Elementary Education Department. The father of the petitioner, Niranjan Das, who was an assistant teacher in the HT 30 Jogainpur LP school in the Karimganj district, died in harness on 7/11/2016. On his death, the petitioner submitted an application for compassionate appointment on 4/1/2017. The said application was considered by the DLC of Karimganj district in its meeting held on 17/7/2017 and was rejected by providing that the usual date of retirement of the deceased servant was 28/2/2017 and he died on 7/1/2016, meaning thereby that there was less than 3 years between the date of death and the date of usual retirement, and therefore under the OM dated 1/6, therefore as per clause 1 of the OM dated 1/6/2015, the petitioner is not entitled to a compassionate appointment. It is pointed out that by the judgment dated. When is the beginning of that order? That by the judgment dated 31/2023 in WPC 1646 and other writ petitions. Other petitions. In paragraph 17 thereof, the clause 1 of the OM dated 1/6/2015 had been set aside on the ground of being in violation of Article 14 of the Constitution. As the basis, as clause 1 of the OM dated 1/6/2015 itself had been set aside, we are of the view that the claim of the petitioner for compassionate appointment needs a reconsideration in as much as it was earlier rejected, as there was less than 3 years of service remaining by invoking the provisions of clause 1 of the OM. Accordingly, the rejection by the DLC meaning set aside matter remanded back to the DLC for a fresh consideration to be placed in the next available meeting. Next one, same. The teacher particulars will be different, and the DLC also same DLC.
Okay.
What is the same? 8/3/2023. What is 8/3/2023?
The petitioner is the president. Petitioner is the section of the Bombay High School. After submission of the representation before the authority against the disaster or issues of the distribution of the fund of the meeting, then the respondent number 6 of disaster, he filed a FIR against the petitioner. Then the letter on the presidency is suspended.
You say against suspension.
Yes.
Seen the report submitted by this. A fire has been lodged against Javidur Rahman as in connection with this fire.
Yes,
So on what ground do you challenge this suspension?
I have the
No, bail is related with the stage of the investigation. Bail nowhere indicates that you have not committed the offense.
without hearing, without notice, without purpose.
No, the FIR and arrest itself is good enough. That there is,
I have taken
that means you are required to take an anticipatory bail, but that will not prove your innocence. And this is suspension. This is not a withdrawal or cancellation. Cancellation, you need a hearing. Suspend, they can always do. They want to possibly drop a proceeding against you. You want to drop a proceeding? Do you want to drop a proceeding against this man? Status of investigation. How do you help? Will it help you? Suppose the status is very good, it's progressing, but how will it help you? See, these are serious allegations. There is an FIR. You are the president, and till the allegation is clear, you are under suspension. What is wrong with that? No, definitely, when there is a FIR, but how can we decide whether it's a false FIR or a right? In writ, we cannot decide that question. Whether the FIR against you is false or right, In this proceeding, I cannot decide. You challenge it, you find a 482 petition against the FIR. If it is quashed, we'll restore back your. Have you understood the contrary implication? Suppose you are actually indulging in this corrupt practice and we interfere with the suspension and bring you back. You'll again be back to your old habits.
But will that not the same benchmark as same day after?
That will also not help you. That's Mr. Peggy, what do you say? Only thing is, we cannot allow the suspension to go on for a long period of time. You take some action. Give him a show cause notice as you place him under suspension. Ask him to show cause. And a criminal case will proceed on its own line. The petitioner, who is the president of the school of the president of the SMDC of what school? Of Bamunbori High School in the Nalbari district. In the Nalbari district, was placed under suspension by the order of the Deputy Commissioner dated 8/3/2023 on the ground that there is an FIR against the petitioner relating to mismanagement of government fund as the president of the school managing committee. Petitioner claims that he had also obtained a pre-arrest bail in the said police case, and accordingly claims that the order of suspension should be interfered. Obtaining a pre-arrest bail may imply the requirement of the petitioner as regards the investigation of police case, but that by itself cannot be material to conclude that the allegation against the petitioner itself is not tenable. As the materials presently available on record, neither warrants an interference with the order of suspension, nor it warrants a continuation of order of suspension. We are of the view that it will be more appropriate if the Deputy Commissioner issues a notice to the petitioner, allowing him to show cause and submit and submit his reply to the allegations against him, and thereafter take a decision on the matter of allowing the petitioner to continue as the president of the SMDC. Accordingly, the Deputy Commissioner Nalbari is directed to issue a show cause notice to the petitioner within a period of 7 days from the date of receipt of a certified copy of the order, and within another 7 days thereof, the petitioner shall give his reply to this show cause notice. And upon doing the needful, the Deputy Commissioner to pass a reasoned order and take a decision as to whether any further action is required to be taken against the petitioner, and also whether the order of suspension is required to be continued with. Dispose of it. Who is he?
Vice President.
Definitely, with the president suspend, you are by default. You are not the original president. So if he comes back, he will be back to vice president. If he is removed, he will become the president. For response.
Item 41.
Same order. Mr. Pegu?
Name of the school.
You agree with it, Mr. Pegu? You agree with it?
My lord.
Same word. Khali name was different.
42.
Same. Page number. Serial number 25. 30, page 25. Page 25 is the bottom. Lokhi Begum. The respondents to file an affidavit. As the respondents to the Deputy Commissioner, Karimbganj to file an affidavit as to why the name of Lokhi Begum at serial 35 in the resolution of the DLC dated 37/2009 was rejected without giving any reason. In this 2 weeks, Mr. Answers.
43.
43.
Condition has been inserted that for the purpose of getting in charge or regular commission matter, one must produce the NOC in respect of the degree of master degree obtained within satisfaction.
So it's very reading.
But I'm page 55, my lord.
55.
And 56 is the actual successful level.
You are assailing 55 or 56?
That would be 55, my lord.
56. What is wrong with 56?
Number 12 and 16, my lord.
12 and 16.
16 is requires that you have to submit NOC from the appointing authority with regard to BEd or master degree.
Just a minute. If educational qualification acquired in service period, please state whether NOC from the appointing authority was obtained. So what is wrong with this?
Wrong manner to be till today, since 1977, matter, teachers of high school and higher secondary school, they have been allowed to pursue matter without giving any.
Can there be equality that earlier it was not done, so now also you cannot do it?
Now, if they make it a perspective, you have no objection.
So they are doing a perspective.
No, they have implemented it.
No, you have to show us. Suppose you have obtained your B.Ed degree in a manner which is contrary to their rules and regulations. They have every right to ask you.
Yes.
How can you stop them from asking? That earlier you did not ask, so me also you cannot ask. I think that is not available.
Yes, that's stopping them. But they have.
Suppose they take some adverse action, you challenge that before the court. Then we'll examine it. But how can you stop them from asking you?
I am not stopping.
You are impliedly you are asking us to do that only by interfering with it.
They have taken the ground that yes, section rule 30 of the 1965 rule, conduct rules requires the commission that you have to take a permission for pursuing as per the MA or B.Ed.
Suppose you had done an act which is contrary to the rules, they can always give you a show cause.
Yes.
They can ask you.
They can issue show cause, they can issue as per.
But for the purpose of principle, they cannot question it. Are you trying to
After
say
10
that?
years, my lord, suppose there is a misconduct on my part, they can proceed.
So you make those arguments when actually some action is taken against you, but not at this stage. You want to file better? Yes. You want to file a video? So you should wait for how much time? 4 weeks time to file a list of reports.
44 and 45 orders.
Yes, Mr. Saitya. both are teachers. Junior assistant in the office of the inspector of schools. So you have challenged his confirmation as well as the gradation list. But- Hmm.
Now, during the pendency of that regulation, the authority have promoted 3 more juniors to me, actually they are juniors to me, but they did not consider mine.
They have not promoted the respondent, but promoted somebody else.
Somebody else.
So interview is only against him, not against the others. So they promoted. No, interim order is against only against one candidate. So authorities found it is not there in respect of others. So promote them.
But then they have not consider my case because the idea of was just 6 and they are evidently junior to me.
Who appears for the respondents? Who appears? Not for the private respondent, official.
And also, usually that one of the those maybe a promoted person has returned, so I can see that I promoted there.
But Mr. Bora, will you support it or will object to it?
Without touching my post,
You are already promoted.
don't notify appearing for 3 of the respondents.
No, are you already promoted? Or for the 3 of the subsequent promoted?
Therefore, one has been promoted without.
But But this will be a half-life order, Mr. Saikia. After some time, nothing will happen again, you will come back to the court.
One has retired.
So let us, why not we decide the issue? I think that will be better. I can send it back, no difficulty. Or Mr. Yu Sharma, what do you say? Why instruction not received for the last 7 years? Whatever it is, these are matters of 2016. Now you can't take a stand, I have no instruction. 6 years, 7 years later. No, Mr. Yu Sharma. These are not matters of the individual learned council that I am appearing for the first time or second time. It's a department. So after 7 years, now how can I accept that I have to obtain instruction? In the motion stage or within the first year, it is okay. Yes, you need some time to obtain. But after 7 years, is it still available? And we are asking you on his suggestion. He says that one post has fallen vacant, somebody retired. If you are willing to consider him, he will be happy. What is your answer to that? No, that is not the answer. Today we are not hearing the main issue, Mr. Chistry. Today we are not hearing the main issue. It will take some time, whether he is entitled or not, or whether the other person right here on the conference. He says that in the meantime, one post had fallen vacant because somebody retired. If you consider him in that post, he'll be happy. He doesn't want an adjudication on the earlier illegality.
Whether that post is still vacant because the commission has on last year has already been up so many posts.
That information, you can provide that. Mr. P.J. Saikia, when Senate Council petitioner states that in the meantime, one of the incumbent LDA or junior assistant had retired from service and therefore a post had fallen vacant. And he would be satisfied if a direction is issued to the respondents to consider the petitioner against such post that had fallen vacant. Mr. SMT Chist, whose name I put? He's not a servant. Mr. Yu Sharma, then counsel for the Education Department, praised for adjournment to provide the information whether the post referred is still vacant. Response, sir. Sorry, Mr. BP Borapati. On the retirement, respondent number 4.
46.
to be for the containers. Sorry. For respondent number 3 and 7, praise for 3 weeks time for doing the needful. Prayer list after 3 weeks.
49.
There is no affidavit filed respondents. Who is appearing for the respondents? Higher secondary school, must be secondary education. Mr. Sharma, please respond. Are you appearing or somebody else is appearing? You are there. Do you want to file affidavit or you don't want to file? You, Sharma, for your place for 4 weeks time to file affidavit, just after 4 weeks. Yes.
50.
Where is the direction of the court? You have filed the writ. Is there any stay order? Mr. P.J. Fugal, Land Council responding states that against the order which is alleged having violated, a writ appeal has been filed, which is yet to be considered. Accordingly, it's prayed that the matter be adjourned for 2 weeks. Prayer of this after 2 weeks.
51.
Yes, it's for the first time. Where is the order violated? Page number. Where is the direction? Directed, yes. And have you communicated?
Yes.
AK Purocast notice 6 weeks, steps registered post 3 days.
52.
Where is the direction? Page number 15.
Yes, sir. Starting from awarding for the page 8.
The direction is
The resolution 1 to 3 declare the result of the inspector.
Dekha. Ye dekha. It's there.
53.
Page number. And communicated. Is the order communicated? So, as to
54 to 57.
Yes, Mr. Dekha. Amendment. What kind of amendment? File a writ petition. No, this is a subsequent decision. A decision to declare you or something to be fake is a subsequent decision. No, whenever you came to know, you challenge it separately. How can it be IA? No. Instead, we give you liberty to file a writ petition. See, amendment is a long process. Ultimately, you will be entangled in that process. Okay. Amendment is, we have to hear them. They'll oppose the amendment. We'll take a decision whether amendment will be allowed or not. Thereafter, you'll file a consolidated writ petition. Instead of that, why didn't you take the easiest way out, challenge the decision in a writ petition, tag it together? Would that be so? That is the law, Mr. Dekhan. Those writ petitions will be anyway pending. No one is going to close them. Take the advice of the wise man sitting behind you. In your new writ petition, you take any ground you want. That will be in addition to your existing writ petition. Okay, fine. Argue. Argue. Yes. On what ground this amendment is offered? Mr. Counsel, if the earlier writ petition is not touched, the interim order will also remain. Okay, do whatever. As you are comfortable, please argue. See, Mr. Decker, we are trying to make it easier for you because amendment is always governed by the law of amendment. It's a tedious process. There may be a situation on their objection, it may be refused also. But your legal right is violated by some order where some document of yours has been declared to be fake. This is your grievance. And you came to know about it a little later. Issue notice on the issue notice, MSS tutel and counsel for the fixed notice list on so and so. Yes, next item.
58,
My rank was number 1 in book 1, 2, and 3.
Petitioner son,
Minor daughter.
minor daughter, appeared in some CBS.
And when the answer script was called for, it was sitting there. Some pages were gone.
Okay, when you call for the answer script, the pages were torn. Okay.
And in biology, physics, and chemistry, and interestingly, the mathematics paper was not of the minor of the. And they put in the record manner on the very first paper. But even after 2 months, they were not highly accredited. The academic says
Now, what is the relief you are seeking? What kind of order?
Yes, Pilot, what I am saying before your lordship is this, Pilot. I may be allowed to appear again under this situation.
No, not Madam Bora. One statement of Mr. Bashir's caught our attention. Why will the answer scripts be torn? By who had to? So whoever it is, that is an act on the part of the respondents. How can that act be prejudicial to a candidate?
We have found the book also. When it was given to the invigilator,
It was torn.
it was like this.
It was torn.
No.
So the invigilator ought to have pointed out then and there
No,
that
when the examiner
sorry,
examiner examined the book also,
it will be.
at that time,
it will be-
they found that there is
So,
a fault.
moment the student handed over the answer script to the invigilator,
They took like this.
Ha,
They never
then
took the inside
then
what
it becomes, but that is your lashes on your part, not on his part.
we have found the
The answer scripts of the son of the writ petitioner in original be produced before the court. No, first you produce the answer scripts. Minor daughter will produce before the court, list on next week. Next week, fixed it.
It was found on this.
We will now order it. We'll now order it. Madam Bora, safer for you, allow him to appear. Otherwise, we are going to make an inquiry. Then we'll make an inquiry. We'll make an inquiry, appropriate action against the official of the CBS. Or other option is, he only wants to appear in a repeat exam, allow it. He cannot do. Then we'll
Lordship direction.
No, we are not.
How-
We are going to inquire into this.
Yes.
Eh,
Who has
and
thought of
act-
that? And she also says there that Latak's books is not hard.
And,
And the same handwriting, Lordship will find, same handwriting.
okay, then the petitioner will be in trouble.
Find the original, yes. Everything will be Lordship.
Okay, next
Who
item,
has torn out the book, Lordship? Accept or
next item.
59 to
It's
withdraw.
59, who is appearing? You want to withdraw? Your name, please? D. Medhi. Does your name appear in the Wakalatama? Mr. D. Medhi. Then counsel for the petitioner has made a statement before the court that the petitioner is that there is instruction for petitioner not to press with this writ petition in the present form. In view of such statement, writ petition stands closed. You want any liberty? Not to file again. Accordingly, writ petition closed. No, on the next day. Next day it will be listed. You make a submission. We'll hear it. Yes, same order.
61 per motion.
Yes.
Yeah, my lord, as per the order passed by the Honorable Court, my lord, page 22, my lord.
Motion.
Yes, my lord.
Why is it still in motion?
My lord, as per the order, my lord, page 22, my lord.
Which order?
Page 22, my lord, this Honorable Court directed to consider, my lord, that DLC, my lord, consider favorably, my lord. And recommended.
Washing aside the impugned minutes of 26(8). Which page? Annex 10.
My lord, this is, my lord, page 30. The civil person, my lord, page 32, my lord.
30.
DLC recommended, my lord, SLC declined.
So you are against the SLC. Where is the DLC recommendation?
My lord, DLC recommended, my lord, page 11 person, my lord, page 27. Item number, my lord, 5.
As per the order of the Honorable Court, the DO
Item 5.
verified the account and no such application. Just a minute. Where is the order of the court?
Page 22, my lord. And 11 person, my lord, page 24, para 3, my lord.
Page 24. The petition was amended at the time of death.
Because then final, my lord, there is another judgment at the next page. 35, my lord, the time limit.
Just a minute. They shall in doing so. We said only if available it should be placed. They say it is not available. Come to page 24. Page 24.
They found, my lord, available.
No. In doing so, DO shall verify from the records whether any such application is available and if available, place it. So
Then, my lord, page 27.
understand that's a conditional order of the court.
Yes.
Now they say, as per the order of court, found no such application. Found no such application found. So the order of the High Court goes then and there, but over and above, they say DLC decided to recommend as per order of the High Court. High Court never gave the order to recommend you. So this is absolutely why the DLC. Court has already passed an order that the person was a minor, says that an application was submitted for compassionate appointment, and the DO shall verify from the records whether it was application was submitted, and if submitted, place it before the DLC, meaning thereby DLC will consider as per merit. Now, what have you done? Firstly, you say no application was found. Then you say DO placed the proposal as per the order of the court. There is no such order of the court. Then you say recommended as per order of the court. Where is the order of the court to recommend? Why are you passing these orders? Now SLC must have rightly rejected. Whatever it is, but this recommendation we cannot accept it. What when we send back means you consider as per merit. Do it as per merit. There is no record. Where is your application? Let us see. No. Where is the application? Because they say there is no application of record.
Page 15, my mother submitted it. This is my lord, they are admitting my lord.
Who is admitting?
Page 15, but they are not admitting my lord, page 18.
What is page 18? And what is
Page 18, my lord, they are sworn, my lord, after becoming major, my lord, step line. Yes, sir, my lord.
You do one thing, Mr. You place the application of the mother before that, yes. That is a good application. No application by the mother also.
My lord, but resolution, my lord, says otherwise. Page 15, my lord.
See, Mr. If your client is a little dangerous client. He is managing something which the court is not providing. Putting in the blame of the court that the court is providing. So for this dangerous a person, it is also possible to get one line written by some official that they are admitting it. Don't you think he's a dangerous person? Last time on good faith we passed some order, but this time we are not having that good faith with this petitioner. Not whole matter. The petitioner to produce the original of the applications made by the mother as well as by the petitioner for compassionate appointment. List also. No, you must be having a copy with you. Everybody retains a copy. This is typed copy. From where did you type it out? Whoever had typed an annexed date must be having something with him from where he had typed it out. Please produce that one. It appears to be a case of fraud, Mr. Boruvia. Now it cannot be taken that lightly. In view of their stance, this appears to be a claim of fraud. If it is a fraud, you have fraudulently obtained one earlier order of the court by making wrong statements. Yes. Earlier order was passed on the good faith that whatever statement was made, and I think it was, who was the counsel? Same. That Mr. Borbuhia had made a right statement. But now it appears that the order was obtained on the basis of false information given to the court. Now we cannot take it that casually. It is not only a problem, it may be a big problem for you.
One line, my lord, is very clumsy. First line, the application received from Srimati Amita Begum for appointment of
Maybe there. Now, who had given the information, Mr. Saikia, that all these statements are wrong? Anyways, then why did the deputy commissioner write this line? Application received. If the education department says there is no such application found on record, why did the deputy commissioner write the application received from so and so? produce the original records of the DLC be produced before the court. Hey, we are not in this foreigners tribunal bench. That this is difference of views and all. Let us go to the core issue. Your stand is there is no such application. Deputy Commissioner writes received one application from the mother, but there is no application from the petitioner. Okay. But the Deputy Commissioner also goes a little beyond the court order, saying that it is the court who had directed to give him appointment, which is incorrect, because the court say only one thing: if any application was submitted and found on records, place it to the before the DLC. Meaning thereby there are two conditions. One, if application is on record. If it is not on record, you don't have to do anything. And if it is on record, place it DLC. DLC is considered on merit. Court never said giving the appointment. So why did the Deputy Commissioner write that we are recommending him as per the court's order? Ask the Deputy Commissioner. It has been brought to the notice of the court that by the order dated 17/11/2021 in WPC 6023/2021, a direction was issued that if any such application is available in the record which was made by the petitioner, the same be placed before the next available DLC of Cachar district. The same order of the court had resulted in the resolution of the DLC of 2/2/2022, wherein it is provided that as per the order of the court, the GEO Cachar verified the records and found no such application of the petitioner. But however, the GEO placed the proposal of the petitioner as per the order of the court, and accordingly the DLC decided to recommend the petitioner for compassionate appointment as per the order of the court. The Deputy Commissioner to show cause as to why the GEO had placed the proposal of the petitioner in spite of having not found any application, when it was the court's order to place the application only if it is found on the records. The Deputy Commissioner to further show cause that when the court has required the claim of petitioner to be placed before the DLC, why is it constitute that it is an order of the court to recommend the petition? Affidavit be placed on the next record. Mr. Sakya, not doing is also a contempt of court. Overdoing is also a contempt. Tell the Deputy Commissioner. And that too putting the name on the court. So now what will people think? That the High Court is directed to give a compassionate appointment to somebody. If necessary, you file an application for clarification before the court that this is the order, this is the situation, what we are required to do. But you can't overreach a court's order. Not you can the court and do what is not required under the law to be done.
62 and 63.
That yesterday's order. Mr. Kotaki, what is your information?
There is a court history matter.
You are given, Mr. Kotaki. Which agenda?
This is number 3.
3.
Basement.
So decision is already taken.
Again. Well, there are 5 posts.
Today is Wednesday. Today is Wednesday.
Yes.
I think we have to file a writ challenging this.
The statute does not provide for, except that rule 4.2. You still
No, that's why I'm
only
saying.
that is inside.
No, that's why we are saying when this decision had been taken by the Board of Management, this is contrary to the
Rule 4.
Rule 4.2. If you put a challenge to this one, this one also.
Fair procedure.
Okay, it is there. It is already challenged. Mr. Kothik, it is already under challenge.
Yes, sir. The copy was not available at that time.
At that time, we will not provide it. That's why we said we will provide it when they provide it.
Okay, but it is under challenge.
It is under the same main.
So we have to state this one. And why you say that you are waiting for some age to be extended to 65? Where is it?
That is my because recently that because we have already not an outlet. That has come recently.
No, no. And how do you justify till the positions are filled up? Why are you not filling up on regular basis then?
After this amendment, because state government has recently issued that. And next week we will getting the copy of the notification. Then automatically, they will be there.
Until then, the HOD will become the dean.
Temporary dean minor, just for few months, 1 month or 2 months.
But if it is contrary to the rules, it is cannot be that casual.
You would also sign that.
No, rules are not silent. Rules are speaking very much, saying that only against a leave vacancy, a HOD can be allowed to discharge the function of a dean. Etc. is always related to the. Suppose today there is a order say you can have Rasagulla, etc. That will mean another item in the nature of Rasagulla, or it will be anything in this world,
Something with leave or
something related to the original word, etc. always is interpreted to be related to the existing word.
our case is not.
It cannot be ever expanding that it will mean everything else.
What is case is that since he has already tenure is finished, it's already over.
Not yet over.
So today, my lord, for 5 years. So
So, have you got that decision? No.
I had a occasion on these things. I had an occasion to talk to my landed colleague whom I respect a lot. He has much more better knowledge than me. He said, what they allow from your lordship is the correct proposition of law.
I think
That if there is a choice between a group who is already selected, and for some purpose the selection process is not in, and there is a group non-selected, then if the decision is taken.
the selected man is a better person.
He was also searching, I have the message. He said, this is the correct proposition.
Possibly there may be
There is a decision.
one decision by Justice Ranjan Gogoi. Most likely.
Our High Court will not see. In school where he said, this is all unreported somewhere. But there is one school maker few years back, where he said, City.
Can you give the name? We can.
He said that going on because he's normally doing service makers. So he said, this is the correct, as a senior counsel, this is I am submitting now for this law. This is the correct proposition of law. That a situation before your launch, before vote, where there the soil is selected, gap is, advertisement is yet to come up, and the group coming before launching for non-selected.
So you go for the selected.
But provided advertisement has to go with a logical call. Moment that advertisement is over, selection process is over, this
will go.
I cannot have a suggesting.
That's definitely not beyond that.
This is the process.
What do you say?
I consider this completed tenures.
Mhm.
And already he has completed his tenure.
Now, today's order will be a final order or it will be an interim order?
I understand, but referring also.
No, so
I leave it to your logic. But only one thing I must be fair. That
Mr. Patel, the time taken for both the orders will be same.
only
Order final or interim.
my
Only the last line will depend. Petition stand disposed of or list again after 2 weeks.
I am at your logic.
The,
I am at your logic.
it will be order of which nature? Because almost everything will be decided.
Because it is not that it should be made clear only, because he is just like my brother, that these orders have also probably not intended to stop the selection.
No, no. The selection start immediately if necessary. And the reason you have stated that there is a contemplation that the overall age may be increased to 65. So we are waiting for it. You did not wait for that. Because whosoever is the beneficiary, now or after selection, that person will anyway go to 65. Become 65. So you don't have to wait for 65 to come. What? Make a regular selection. Until then, let this person continue.
My position my flexibility requires.
Yes, we'll give a we'll give a reason also why we are not accepting it. Heard Mr. K.B. Martin, runs in a council for a petitioner, assisted by Mr. M. Sharma, Mr. T. Kapti for the respondent city, Assam Agriculture University, and Mr. S. Das for the Education Department of the Government of Assam. All of them are deans, Vivekananda, Saikya, and Jayanta.
First one, faculty of veterinary science.
Or the different subjects,
One,
the different departments,
different faculty.
faculty.
First one is faculty of veterinary science. Next is faculty of agriculture, like faculty of fisheries and ocean.
Writ petitions WBC 4995/2023 and 4996/2023 had respectively been instituted by Dr. Vivekananda Saikya and Dr. Jayanta Dekar. Dr. Vivekananda Saikya was appointed as the Dean of the Veterinary Science Faculty of the Assam Agriculture University by following the due procedure as provided in clause, when is that step? Page number 70 something, 651. By following the procedure prescribed under chapter 3 of the first statute under the Assam Agriculture University Act 1968. Whereas Dr. Jayanta Dekar was appointed as the Dean of the Faculty of Agriculture in the same university, also by following the same procedure. The respect, Dr. Vivekananda Saikya was appointed. Which appointment order, Mr. Saikya?
Appointment order, appointment is expiring tomorrow. Order is at page number. Page 87, 74. Page 74.
74. Dr.
or additional affidavit, no matter, I have to file additional affidavit. It's
Vivekananda.
127. The appointments was cross.
This
So,
both are, I think, is the same date.
same day.
Both Dr. Vivekananda Saikia and Dr. Jayanta Dekar were appointed as deans of their respective faculties by the orders dated 30/8/2018 of the Registrar Assam Agriculture University. The respective orders of appointment provides that the appointment is for a tenure of 5 years with effect from the date of joining or till the person concerned attains the age of superannuation, whichever is earlier. It is given to be understood that the expression attains the age of superannuation, one inverted comma, in the two respective appointment orders would have to be understood to be the age of superannuation of the two appointed deans as per their original post which they held in the Assam Agriculture University prior to being appointed as a dean. Admittedly, both Dr. Vivekananda Saikia and Dr. Jayanta Dekar were senior professors in the Assam Agriculture University, and admittedly their age of superannuation otherwise is 65 years. At the time of being appointed as dean by the order of 30/8/2018, Dr. Vivekananda Saikia was aged about 57 years and Dr. Jayanta Dekar was aged about 59 years. And presently, Dr. Vivekananda Saikia is 62 years and Dr. Jayanta Dekar is 64 years. As their age of superannuation would be beyond the tenure of 5 years from the date of appointment, comma, and as the appointment was by the order dated 30/8/2018, the tenure is likely to end on
From tomorrow meeting.
on 30/8/2023 as admitted by both the petitioner as well as the respondents in the Assam Agriculture University. The two petitioners are aggrieved to the extent that upon their original tenure of 5 years coming to an end, the respondents in the Assam Agriculture University ought to have initiated a process for regular appointment of a dean as per the provisions of Chapter 3 of the first statute. But instead of initiating a regular process, the Board of Management of the Assam Agriculture University in its 263rd meeting held on 19/8/2023 in respect of the agenda number 3 corresponding to consideration for engagement of in-charge officers against the positions of statutory officers to be vacant in different positions of the Assam Agriculture University, had taken a decision that in respect of the position of Dean Faculty of Veterinary Science and Dean Faculty of Agriculture, the senior-most HOD of any department of the Faculty of Veterinary Science or the Faculty of Agriculture, as the case may be, would be selected to be the respective deans till the positions are filled up on a regular basis. Mr. K.B. Pathak, Senior Counsel for the petitioners, have acceded the said decision of the Board of Management of the Assam Agriculture University by referring to 7. By referring to
Page 7.
sorry,
Page 17 is the prayer.
17 is a prayer.
One second.
No, I'm referring to that 4.2. By referring to clause 4, clause or section, what is called clause? Clause 4.2 of the first statute under the Assam Agriculture University Act 1968. Clause 4.2 is extracted as below. Mr. K.B. Pathak, London City Council, by referring to the provisions of clause 4.2, submits that an appointment of a dean under clause 4.2 can only be made upon the condition precedent being satisfied that the regular dean is on earned leave, etc. And in that circumstance, the head of the department nominated by the vice chancellor can act as a dean. In the instant case, the condition precedent would not be satisfied inasmuch as the 2 deans who are appointed on a regular basis would complete their tenure of service. And upon the completion of tenure, clause 4.2 is sought to be invoked to appoint the head of the department as the dean. And in such circumstance, the condition precedent that the dean would be on an earned leave, etc., is not satisfied. Mr. K.P. Pathak, London City Council, by further referring to the provisions of Chapter 3 of the first statutes of the so-and-so, submits that there is a statutory provision providing in the manner in which a dean is to be appointed upon the completion of the tenure of the earlier regularly appointed dean. And the authorities cannot substitute the provisions of Chapter 3 and invoke and clause 4.2 to appoint a dean upon the completion of the tenure of the earlier regularly appointed dean. Mr. P. Kotoki, Learned Counsel for the Assam Agriculture University, on the other hand, produces a copy of the proceedings of the 263rd meeting of the Board of Management of the Assam Agriculture University and submits that the appointment of the head of the department of the respective faculties is only a temporary measure till the posts are being filled up on a regular basis. And as such, it would be permissible for the Assam Agriculture University to appoint the respective heads of department as the deans of the 2 faculties. Mr. Kotoki also states that there is that a process is already undertaken, that the age of retirement of the deans may be extended up to the age of 65 years. And upon it happening, and therefore, the respondents are not going ahead with the selection of a regular dean as per the provisions of Chapter 3. The first submission of Mr. P. Kotoki, Learned Counsel for the Assam Agriculture University, would raise an issue as to whether a person who has not undergone the rigors of a regular selection process can be allowed to hold a given position in charge when candidates who have actually undergone the rigors, selected, appointed, continued and completed the tenure are also available for the purpose. In other words, a consideration is to be made when candidates who are subjected to the rigors of a regular selection is available, whether by ignoring them, the authorities can offer their appointment in an in-charge manner to a person who is yet to undergo the rigors of a regular selection. We, as already extracted, we noticed that Chapter 3 of the statutes under the Assam Agriculture University Act 1968 provides for an elaborate procedure as to how a dean is to be selected for being appointed on a regular basis. Clause 1A of Chapter 3 itself provides that a person, in order to be appointed as a dean, would require to have the qualifications for the post, which again would be in consultation with the ICAR and other agricultural universities, meaning thereby that the qualification itself is of paramount importance. Clause 1B provides that a post will then be advertised. Clause 1C provides that there shall be a selection committee for the purpose of recruitment and the selection committee shall consist of the vice chancellor being the chairman, one expert member nominated by the ICAR, one member to be nominated by the chancellor, and one expert member from outside the university to be nominated by the vice chancellor. The composition of the selection committee itself appears to be an expert body for the purpose. On the other hand, when we compare the eligibility and qualification of a head of a department, it is noticed that there is no evaluation as to whether the head of the department would have the qualifications as may be provided in consultation with the ICAR. Secondly, the head of the department is only a regulation post on a prevailing service condition and is not a post where the incumbent is subjected to any competition from any other equally competent persons. And thirdly, and most importantly, the head of the department is not subjected to the scrutiny of the selection committee comprising of experts as indicated above. When we take note of the manner in which a dean was earlier selected and appointed, and the manner in which a head of the department is functioning in the university, we can safely conclude that if a situation arises as to what is to be done in an interregnum till the regular dean is selected, the answer obviously leads to a conclusion that a regularly selected person, if still available in a university, would be more acceptable than a person who had not undergone the rigors of such selection. It is stated that the head of the department is also selected under such procedure, but even if it is so, it is not the case of the respondent university that the same rigors of Chapter 3 would be followed. And we are in no way undermining the eligibility or qualification of a head of the department, but on the other hand, we are only comparing the manner in which comparing as to whether the rigors of Chapter 3 are satisfied or not. What was the second submission? Your second submission.
Since it is scheduled post.
The other submission of Mr. P. Kotoki is that the post of the dean is a tenure post of 5 years. And as the repetitioners have completed that, would have completed or would complete the tenure of 5 years, therefore they cannot be extended any further. The same submission would have to be looked from the perspective that what would happen in the interim till a regular dean is selected is not provided in the statutes in any manner. Even if we look at the provisions of clause 4.2 of the statutes as indicated above, a head of the department can be allowed to be the in charge dean only in a circumstance when the regular dean is on a earned leave or etc. Mr. P. Kotoki tries to contend that the word etc. would also include a circumstance when the regular dean, when the tenure of the regular dean had come to an end. We are afraid that we are unable to accept the said contention in as much as the word etc. would have to be read with the principal word in the provision itself, that is, which in the case is the regular dean is on an earned leave. The word etc. cannot expand the scope of the principal word to which the word etc. is attached to it. We are also unable to agree with the views expressed by the respondent, Assam Agriculture University, that the regular selection had not been initiated as because there is a proposal that the age of the dean may be extended to 65 years. If it is so, and even if it is ultimately accepted, that cannot be a reason as to why a regular dean would not be selected and appointed. And it can always be understood that whosoever would be appointed as the regular dean would be governed by such proposal, which may ultimately be accepted, that the age of retirement of the dean would be 65 years. The reasoning given by the Assam Agriculture University not to proceed ahead with the regular selection appears to be unacceptable. To stop. From such point of view, and also from certain considering the prima facie case being made out, and also considering the balance of convenience as well as the irreparable loss between the parties, we are of the view that it will be more appropriate if the selected, appointed deans who have completed or would complete, or have completed the tenure in comparison with the head of the department would be more appropriate to discharge the function of the in charge dean till the regular selection is made. But however, we also require the Assam Agriculture University to immediately initiate the process of a regular appointment of a regular dean so that the tenure of the in charge dean is met to the minimum. Issue notice returnable in 4 weeks and this and so and so. Extra copies.
With this order, the matter can be disposed.
That's why I'm asked you. It depends only on the last line. The order time will taken will be same.
Because this is fine. In view of the
It's also final.
in view of the opposite order, it should be disposed of.
This is a primary view. Notice returnable so and so extra copies to the land council. Any private respondent? Only, no, only notice. Here. Extra copies 3 days. Any private respondent? No.
No.
65.
AMS Modimdar, yes. Mr. Modimdar.
High school.
No, 24/7. This is a order of merger, amalgamation. On what ground do you challenge?
High school, primary school, and other schools are within campus, then it can be amalgamated.
Understand. And if it is not within the same campus, it cannot be.
The LP school cannot be. There is no provision. LP school cannot be amalgamated beyond the campus.
Which provision? Page number.
Page 21. Rule 7. Rule 7. After that, and right, optimal service of the employee and other work. Besides the schools situated in the same campus or any other area, market, all the schools have been brought into one single administration and academic and other all the schools situated in the same campus and marked with the high levels.
Highest levels. No, that means if there is a ME and LP, merge with ME. If there is a ME, LP and high, merge with the high. Standalone high school. You're situated near a senior high school. No, which is your relevant? You are relying on which clause? Come straight away. You come. Mr. It will be helpful for you as well as us if you point out the relevant clause which you are relying on to make out your case.
I'm saying from 1 to 10, these provisions are within the campus.
No. Read it. Situated in the same campus or nearby area. So both are included, same campus as well as nearby. So it is not necessary that it has to be in the same campus. Please read 7.
And another page, in our school, we are not 112. And we 112 below 100.
Achha, above 100, you cannot be amalgamated. Where is that provision? Page number. Page number 23, clause 13. If 2 or more LP schools are located within a radius of 1 kilometer, may be merged provided that the number of students does not exceed 100 in each school. So even if it is located within 1 year, if it exceeds 100, it cannot be amalgamated. This is what you are trying to do.
One control. That's not logic. The procedure is a procedure logic. There is a committee because 17 logic. There are 3 committees are there. Block level committee, level committee, and thereafter logic. But all these things have been done by logic. But school authority has not done anything without knowing that people in the school authority.
Is there any necessity to give a hearing to the school before merger? There is no such provision. It is their school, they are maintaining it. They have floated a scheme and they are doing it. It is, school has nothing to say. It is not your school, it is their school. So they will take the decision how they will run their schools. The individual schools or the guardians, or they don't have any legal right of their own.
There is a
See, we can do it only when under the scheme there could not have been a merger of this category of school. Then we'll interfere saying that you can't do it even if it is your school because it is beyond your scheme. But if it is within the scheme, it's their discretion. So we can examine whether clause 13 is 13. Yes, Mr. Question. Does the school have more than 100 children students or less than 100 students?
Clause 13. It says about 2 LP schools.
2 or more LP schools may be merged provided number of students of the 2 schools added together or individually. So if
number of students.
so what will happen if student is more than 100? You cannot.
But if 2 schools, LP schools are merged, here is a school where the LP school is merging with the secondary school.
Okay, so 13 is not applicable.
Basically, but from their grievances is that these teachers' service conditions are same. That is their grievance. And they cannot have a right of that.
Great problem. Mr. Muzumdar, then this will be a grievance within the meaning of clause 19. Just come to clause 19. The aggrieved institution. So you will find out if you say that the 2 schools are located across the road, if amalgamated, students may be affected because they'll be running around from one campus to the other and cross the road. That is a grievance. You go and find an appeal.
Such scenario, physical inspection.
No, instead of filing the representation, when the scheme itself provides for filing an appeal, avail that opportunity. Okay. Heard Mr. A.M.S. Mojumdar and counsel for the petitioner. Also heard Mr. B. Kaushik and counsel correspondence in the secondary education, elementary for both secondary and elementary education department of the government of Assam. The petitioner being the school managing committee of Dokhin Borjar LP School is aggrieved by the decision of the respondent authorities. Where is the merger order? Page 26. By the merger order colony. By the order dated 24/7/2023 to have the Dokhin Borjar LP School merged with Borjar High School. Mr. Mojumdar, by referring to the scheme of amalgamation, firstly submits that a merger can take place only in respect of schools which are located in the same campus by referring to clause 7 of the scheme. But prima facie, it appears that the state's contention may not be acceptable in as much as clause 7 provides that the merger can be effected in respect of schools situated in the same campus or any nearby area. And full stop. Which means that even schools located in a nearby area can be merged, but amalgamated can be amalgamated. The other contention of Mr. A.M.S. Mojumdar is that as per clause 13 of the scheme, 2 or more LP schools can be merged only when they are located within a radius of 1 kilometer and schools does not have more than 100 students each. But it is countered by Mr. B. Kaushik when comes for the education department that the said clause is applicable only when the amalgamation is between 2 or more LP schools. But in the instant case, it is an amalgamation of a high school and LP school. Mr. A.M.S. Majumdar further submits that the two schools are separated by a busy road in between. And therefore, if the merger takes place, the small children may run across from one part of the school to the other part after the amalgamation and may be exposed to the risk of crossing the road. If that is so, we are of the view that it may be a grievance on the part of the writ petitioners, and for the purpose of grievance, there is a provision under clause 19 of the scheme that the aggrieved institution or public may make an appeal before the government in the secondary education department or elementary education department. In view of the provisions of section 19, the petitioners may institute an appeal before the government under clause 19, bringing their grievance to the note of the authorities that as the two schools will be separated by a busy road, the children may be exposed. Upon such appeal being filed, the government will pass a written order within a period of 2 months from the date of receipt of such appeal. Yes, Mr. Kaushik, what do you say? Should there be an interim order? Sorry. Till the reasoned order is passed by the government upon the appeal being filed within a period of 2 months as ordered from the date of submission of the appeal, a status quo on the amalgamation be maintained. On the other hand, if no appeal is filed within a period of 15 days from today, the interim order shall no longer hold good.
66 and 67.
For
66 and 67. For 66 IA, no, one is IA Civil 1988. Who is appearing? You are ready? Are we required to take up that IA today? That's why I'm asking. This one. Okay, you were appearing for the. No, that's why I'm saying the number of petitions are there. So let us go one by one. IA 1988, you appear for the applicant. Who appears for the writ petitioner? Mr. Chaudhary appears for writ petitioner. You intend to file objection, Mr. Chaudhary? Already filed. So we can hear that matter. Okay. And what about WBC 1635? You are appearing petitioner. So that will go with the IA. What is IA 2468? So now instead of he filing an IA, you have also filed an IA on behalf of some other respondent. Okay. You have to file it. IA 2468. Mr. M.K. Chaudhary, London Senior Counsel for the writ petitioner, pays for a week's time to file an objection to the interlocutory application. Any more order we have to pass today?
don't order to also because the order is that the selection.
226 we cannot continue. If it is 226.3, by operation of law it is vacated. And if it is so, we can pass a new interim order. But otherwise, because if court passes an order, it will be in conflict with 226.3.
The order itself is such.
Normally, the respondents, sorry, normally the respondents they retain the interim order. They don't take 226 and then consider it to be vacated. When you want, let's talk.
12th August. 12th September.
And your IA, you want to urge upon it today? No, ABJ cannot be dependent on your senior. No, because if you don't urge, you won't be allowed to take advantage of 226.3 because we are ready to hear you. Because otherwise, in their case, it may be 226.3. That's a very constitution concern. Difficulty is 226.3 is was the limit of the court, I think, where any party gets to India, whether by instance stay whenever is made on any proceeding with the petitioner without furnishing so and so, makes an application to the High Court for vacation and furnishes copy, the High Court shall dispose of. The constitutional mandate is on the court, not on the litigants. This is the difficulty. So, if we don't do anything in that IA, there is a constitutional direction to the High Court to, and if we don't do it, the onus is on the court, not on the parties, and the parties cannot come into agreement between them also, because by operation of law it goes away. Then the resultant situation is court may again hear the prayer for interim and may pass a new interim order. So if I don't hear your application, what will happen?
Nothing will happen because when the order considers that the selection process.
No, about the interim order, what will happen?
So that's why I'm reading the operating the selection process in India College shall not be finalized without leave of. The leave has to be taken.
But that is again an interim order. But that is also a injunction or a stay in a way. That provision for without leave will go away now.
Asking for leave.
Why don't you argue your matter or do something? Then we can pass one line order here and there, then save the situation.
There is no difficulty.
But again, it will be the same issue, I think, more or less.
My friend, nothing will happen. I do.
In this also, it's a good way.
Then maybe worship may like to disclose the entire job. Because the issue of IA and payment.
Definitely. If you have to hear in detail, it's better you pass the final order.
And this is not a person to the right of the petitioner, a good person to the worship. They are already in judgment, appointment of assistant professors to worship directors that the rationalization has to be done. After taking the selection process, rationalization of marks.
Nothing has been done.
Person who had used any appeal file against that order. What happened in the appeal?
No, nothing.
Because the marks that are given 10 years back and the way marks are given as of now, it's not with the same strictness.
And the result is that some young young candidates who have been appointed without PhD degree, and those persons, older persons with PhD degree from the graduate themselves. So that rationalization of the stand of the government is that no, prior to the quota regime, we have already rationalized when we issued the modification. That is the stand.
In what manner it was rationalized? No, in what manner it was rationalized? Rationalized means you bring some kind of a equality.
Nothing has been done. I'm so confident.
Merely saying we have done it may not be rationalization. So otherwise, see, even we are aware when we passed our matriculation, if you get a first division, there will be people will be gardening you.
My lord,
Because
our times, my lord,
even that was
4 students when they got first, second, fourth, and seventh rank, they did not have given a star marking itself.
that's why. If you get a 60% first division, your neighborhood will be giving you a garden because you have performed very well. Now that first division is almost nothing.
Even if one gets 90% more,
So therefore, over the period, the manner in which the strictness of the examination is done, evaluation of the is done. Different. We are not passing any orders. We keep in the sorry. Any way you want.
68 for the hearing.
What is this matter? Areas salary of petitioner.
After the appointment, they got the salary for a few months. From 95 days of getting the salary, the government formed a committee called Monitoring Committee to do the appointment of education teacher. So the Monitoring Committee report categorized teachers into 3 categories. One was regular category of teachers, they were appointed regularly in the section. Another was irregular category. The irregular category teachers, the appointment were made in a section taking post, but some procedure.
But without following the
Yes,
procedure.
some procedure was not followed. And third was illegal, they were publicly illegal, yes, non-existent post.
Post is also not there, appointment is.
So the Monitoring
So now petitioner belongs to which category? Second category.
So the cabinet took a decision of regularizing our services. Our services were regularized on 5/3/2001.
Where is the cabinet decision?
The cabinet decision is not there. Pursuant to the cabinet decision, a circular was issued. That is there, at page 20. It refers to the cabinet decision. Any,
Page 20.
yes. Pursuant to cabinet decision dated 21/2000, the government of Assam had decided to regularize 3 factor numbers of LP senior basic, junior basic service school teachers. Senior subdivision districts who were appointed irregularly during the period from 1/3/91 to 30/11/96 and onwards, which were employed by the one-man committee headed by Shri S. Manmohan.
You are you are I Chaudhary.
No, I'm S. Bishop.
Yes.
S. Bishop.
Mr. Vishwakarma. This page 20, it is to inspector of schools.
Yes.
District deputy inspector. Whatever it is. Treasury Kapoor. Assam has decided to regularize 3511 number of SP basic teacher in your subdivision district. This figure of 3511 pertains to any subdivision, pertains to any Kamrup district, or it pertains to the whole of the state?
This pertains,
Because it's not very clear, you see.
it is not very clear.
And is your name included in that list of 3511?
These are relative statements.
Where is that list?
That list is not that.
Do you have the list with you? Suppose the name of the petitioner do exist in that list. I think he has some legal right by virtue of the cabinet decision. And if it is not there, we have to look it otherwise. I think first step is you produce that list. The petitioner relies upon a circular dated 10/8/2000 of the Education Elementary and Secondary Department of the Government of Assam, wherein in clause 1, it is provided that there is a cabinet decision dated 21/2/2000 of the Government of Assam to regularize 3511 numbers of LP stroke senior basic stroke junior basic stroke ME stroke MEM stroke HS stroke HS school teachers in the subdivision stroke district who were appointed irregularly during the period 1391 to 30/11/1996. Petitioner claims that his name is also included in the 3511 number of teachers referred above. The respondents in the Education Department may produce the cabinet decision along with the list of the 3511 number of teachers for examination of the court as to whether the name of the petitioner is also included therein. List down.
15.
First, you see if it is there. If it is there, we have to look at in one particular manner. If it is not there, again, we'll have to hear you for it.
Apart from that, this 3511, the average.
One more.
Yes, average allocation from the government, that the declaration order would be passed, and on 100 will be given by that, they will be not claiming their address.
Then you produce that also. So now you are regularized.
Yes, I recognized, and they will.
In which year?
I was initially invested in 2001.
2001. So now what is your grievance?
My salary is from 2001 to 2005. I did not get. From 2000 April 2005.
No, where is the order of regularization?
Order of regulation is at page 23.
23.
So one of the petitioners petition on
First,
in persons of
who was
government.
appointed as the Gopal Administrator.
This regulation order is prior to they have been examined by the one.
No, cabinet decision is of 2000.
I'm sorry.
Cabinet decision itself is of 2000. So must be
This order refers to that particular circular page
is
20.
hereby regularized with effect from 1/8/2000. Very well. So from 1/8/2000 to 2005, salary was not paid. Thereafter, it's paid. It's regularly paid. It is also stated that in respect of the petitioner number 1, Monopati Deka, the services were regularized by an order dated 5/3 or 5/13. Mhm.
The next page below says it is.
No, in page 23, how does it look like to you?
It looks like
5/3/2001 with effect from 1/8/2000. It is the grievance of the petitioner that although his services were regularized with effect from 1/8/2000, the regular salary had been paid from the year 2005 and not from 1/8/2000. In this writ petition, the petitioner claims the arrears salary for the aforesaid period. The respondents to also provide the information to the court as to why the salary for the aforesaid period has not been paid. And secondly, whether under the law, the petitioner would be entitled to salary for the same period. List on. Why these matters are pending for almost 11 years now?
Coming up regularly for competition.
For 12 years, it could not be taken up. Thank you.